Breaking news now, the Supreme Court has thrown a challenge to California's restrictions on religious gatherings back to the lower courts for reconsideration. Now, remember, the Supreme Court just ruled a short time ago in favor of New York, saying they could not prohibit different sizes of crowds at churches. Well, now what the Supreme Court is saying is they are throwing it back to a lower court to have them reconsider whether the state can dictate how big church crowds can be. This is important because it now mandates that the lower court take a look at this again. It keeps the mandate by California in place, but again, this will put it at the top of the to-do list on the lower courts to get this ruling out in short order. We'll have more on this as it comes in to America's Newsroom.
Meanwhile, Kentucky's Attorney General and a private Christian school have filed an emergency request with the Supreme Court trying to overturn the Democratic governor's executive order to shut all schools down. Joining us now is Roger Byron, the attorney for Danville Christian School. Thank you for being here this morning, sir. So the Kentucky Attorney General is arguing that private religious schools should be allowed to be open under the governor's current orders. Why?
Well, the First Amendment generally requires a government to treat religious gatherings of people just as well as it treats other gatherings. And in a COVID-19 context, this means that a government can almost never apply restrictions to religious gatherings that it doesn't also apply to other gatherings. And other gatherings include things like going to the movies, shopping at a retail center or a shopping mall, going to work in an office, going to work in a factory, or attending a wedding. And yet in Kentucky, almost everything is allowed in person, but private religious K through 12 schools have been closed.
I will read a bit from the lawsuit, which sounds a lot like what you just said. In Kentucky, one can catch a matinee at the movie theater, tour a distillery, work out at the gym, bet at a gambling parlor, shop, go to work, cheer on the Wildcats or the Cardinals, and attend a wedding. A parent can send his or her child to daycare or preschool, and college students can attend classes. But all of Kentucky's religious schools are shuttered. We know that there has already been, sir, a response from the U.S. Court of Appeals. It ruled on Sunday that the governor's orders to close schools can stand. And here's the statement from the governor. While we all want to get our kids back to in-person instruction, the United States Court of Appeals for the Sixth Circuit recognized that doing so now would endanger the health and lives of Kentucky children, educators, and families. Do you further challenge that notion based on the fact that you've got Dr. Anthony Fauci saying we've got to get the kids back in schools? There's really no evidence that kids are spreading this when they're in the classroom?
Well, certainly. I mean, in Kentucky right now, under the governor's orders, the same group of people could attend a friend's wedding and then head to the gym together for a workout. Afterwards, they could catch a matinee at the movie. They could attend a concert, or as you said, they could attend a UK basketball game with thousands of other people in Rupp Arena. Afterwards, they could swing by the liquor store. And if they wanted, they could go out and get a tattoo. And they could finish up their night at the indoor gambling slot machines down at the horse tracks. What can they not do? They cannot attend a Bible class at a private religious school. That is not what the First Amendment requires.
We know that Justice Brett Kavanaugh, who will consider the filing, asked the governor to file a response by Friday. Has there been one yet?
Not to our knowledge, but we're expecting a response by tomorrow.
And Justice Kavanaugh, can act alone or refer the case to the full Supreme Court. We will be watching this closely, sir. Appreciate you coming on. We'll follow up with you. Thank you.